Let's take a closer look at the BBEA. Take a look at the BBEA form here. The Buyer-Broker Exclusive Employment Agreement, BBEA, introduced in 1995 by the Arizona Association of Realtors, AAR, is not a unilateral agreement. It is a bilateral binding contract between the buyer. Here is a line-by-line explanation of page 1 of the Buyer-Broker Exclusive Employment Agreement, BBEA, Arizona Realtors, August 2024. Edition, Header Section, Buyer-Broker Exclusive Employment Agreement. This is the formal title of the contract that creates a binding employment relationship between the buyer and the real estate broker. Document updated, August 2024, indicates the most recent revision date of the form. Disclaimers at top, pre-printed portion, legal consult, etc., states that the Arizona Association of Realtors, created the form. It doesn't offer legal advice and encourages seeking legal or tax advice when needed. Notice to buyer. All realtors, are required to have a signed written agreement prior to showing a home to a buyer. Lines 1-3. Party identification. Buyer. The name of the person is entering into the agreement as the buyer. Broker. The brokerage firm entering the agreement with the buyer. Agent. The individual licensee, agent, representing the buyer through the brokerage. Lines 4-6. Agreement language. 4-6. Agreement clause establishes that the buyer grants the broker the exclusive and irrevocable right to represent them in purchasing real estate during the agreement's term. Line 7. Multiple agreements warning disclosure of possible overlap. Warns the buyer that signing more than one agreement could result in liability to compensate multiple brokers, an important risk management notice. Lines 8-10. Term of agreement, 8-10. Term specifies the start and end, date, time of the agreement. Without dates, the agreement is incomplete. Lines 11-16. Employment terms. Employment. 11-13. Employment scope. Property type. Describes the broker's role and defines the types of property the buyer is seeking, e.g., residential, land, commercial. 14-16. Employment scope. Services. Clarifies that the broker will locate suitable property, help negotiate terms, assist with the transaction from start to finish. Lines 17-18. Agency relationship, 17-18. Agency disclosure. States that the broker's agency relationship is outlined in the READ form, Real Estate Agency Disclosure and Election, which must be reviewed and signed. Lines 19-21. Exclusivity notice, 19-21. Exclusive showing clause. Buyer agrees to work only with this broker and be accompanied by the broker on the first visit to any property. Warning. If the broker doesn't attend and the builder-seller pays another agent, the buyer might still owe compensation to their broker. Line 22. Inspection advisory. Arizona Department of Real Estate Buyer Advisory. Buyer agrees to review this official advisory document, which outlines their responsibilities, including due diligence and inspections. Lines 23-26. Compensation disclosure. 23-26. Clear disclosure on compensation. Reinforces that buyer-broker compensation is negotiable and not set by law, MLS, or associations. Service only occurs when compensation is negotiated. Line 27. Initials. Buyer's initials. The buyer initials here to acknowledge understanding of compensation disclosures. Lines 28-30. Retainer FE 28-30. Optional retainer fee. States whether the buyer agrees to pay a non-refundable fee up front, e.g., for consultation or research. It also clarifies whether this fee will be credited toward the final commission. Lines 31-36. Commission, Clause 31-36. Broker compensation, contingent on close. This section describes how the broker will be compensated if the buyer closes on a property. Buyer agrees to pay either a percentage of the purchase price, a flat amount, or a custom arrangement, Page 2 of 3 of the Buyer-Broker Exclusive Employment Agreement. Here is a line-by-line explanation of Page 2 of the Buyer-Broker Exclusive Employment Agreement, BBEEA, Arizona Realtors, R. August 2024. Edition. Lines 37 to 38. Payment of broker compensation. Broker compensation shall be in U.S. currency and paid at closing unless otherwise agreed in writing. Establishes that payment must be in U.S. dollars at closing or as otherwise specified in writing. Lines 39 to 48. Compensation from seller, seller's broker, 39 to 40. The seller or seller's broker may offer compensation to the buyer's broker. If so, the buyer authorizes the broker to accept it, which will be applied to the buyer's obligation. 41-43. If the seller's offer is more than what was agreed to in this agreement, the excess will go to the buyer, e.g., for loan costs. If it's less, the buyer may need to cover the difference. 44-46. Buyer can request the seller to pay the balance as part of the purchase offer, but this is negotiable, not guaranteed. 47-48. VA loan notice. If the buyer uses a VA loan, regulations prohibit the buyer from paying a broker's fee unless it's covered by the seller. Lines 49-52. Failure to complete. If an acceptable property is located but the transaction fails due to the buyer's default, the broker may still be entitled to compensation. If failure is due to other causes, e.g., seller cancels, compensation is not owed. Lines 53 to 57. Compensation after expiration. Outlines cases where the broker is still owed compensation after the agreement ends. If the buyer purchases a property the broker showed, a property under contract during the term, or a property under escrow that began during the term. Buyer has a responsibility to compensate even after expiration if the purchase stems from the broker's efforts. Lines 58-61. Listings and instructions. The broker will show properties that match the buyer's criteria regardless of the seller's offer of compensation. If buyer doesn't want to see properties with no seller-paid commission, they must give the broker written instructions. Line 62. Notice. If the buyer gives that instruction, to avoid non-compensated listings, they must put it in writing. Lines 63 to 67. Equal housing opportunity broker agrees to comply with federal, state, and local anti-discrimination laws. Broker cannot disclose demographic or ethnic information, except to accommodate disabled buyers. Lines 68 to 69. Other buyers. The buyer understands the broker may also work with other buyers seeking the same properties, and accepts that as part of real estate business. Line 70-75. Release of broker. Third-party services. Broker may suggest outside professionals, e.g., inspectors, lenders, but they are not responsible for those third parties. Buyer agrees to hold the broker harmless if they choose to hire one. Important. Buyer must do their own research. This clause protects the broker from liability for third-party service issues. Line 76. Initials. Buyer initials again to acknowledge these disclosures and releases. Lines 77-80. Additional terms and conditions. A space to write any custom additions or modifications to the agreement. Lines 81-82. Alternative dispute resolution, ADR. Buyer and broker agree to resolve disputes through mediation first, following local or state realtor procedures before considering litigation. Here's a line-by-line explanation of page 3 of the Buyer-Broker Exclusive Employment Agreement, BBEEA, Arizona Realtors, R. August 2024. Edition, lines 83-85. Attorney fees. If either party brings a legal action to enforce the agreement, the prevailing party can recover reasonable attorney fees and court costs. This clause deters frivolous lawsuits and encourages resolution through mediation first. Lines 86-90. Additional compensation disclosure, ARS, Prior 32-2154A. Brokers must disclose in writing any compensation or financial benefit they may receive from third parties, e.g., title companies, lenders, inspectors, related to this transaction. ensures transparency and compliance with Arizona law, protects the buyer from hidden incentives or conflicts of interest. Lines 91 to 93, entire agreement. This agreement replaces all prior oral or written agreements between the parties, can only be modified if changes are in writing and signed by both parties. This entire agreement clause avoids confusion from side agreements or verbal promises. Lines 94 to 96, electronic signatures. Parties agree that digital signatures, e.g., via DocuSign or similar platforms, are legally binding, critical in modern real estate transactions, which are largely paperless. Lines 97-100, copies and counterparts. Multiple counterparts, i.e., copies, of this agreement can be signed separately and still form one binding agreement. Also clarifies that legible facts, photocopy, or digital copies are valid. Lines 101, 102, additional attachments, space to list any additional forms attached to the agreement, e.g., buyer advisory, read form, market conditions advisory, etc. Lines 103, 107, signature blocks buyer, signature and date buyer, printed name, broker signature and printed name, agent signature, and printed name signing finalizes the agreement and binds both parties to the terms discussed throughout pages 1 to 3. Breakdown: what it is. A bilateral employment contract where the brokerage agrees to represent the buyer and perform duties like locating property, negotiating, etc. The buyer agrees to work exclusively with that brokerage and compensate them, typically via commission, either paid directly or through cooperation with the seller's broker. It creates agency, meaning fiduciary duties, loyalty, obedience, disclosure, etc., are owed to the buyer. What it is not. It is not unilateral because both parties have enforceable obligations. It is not just a disclosure like the read form. It creates legal and financial obligations. Legal characteristics. Binding. Yes. Once signed, both sides are legally bound. Exclusive. Typically exclusive, meaning the buyer agrees not to use another broker during the term. Term-based, has a start and end date. Compensation clause, outlines how and when the broker will be paid, important under new NAR MLS policies. Why this matters today. With recent changes in MLS choice and buyer compensation practices, the BBEEA is increasingly important. It's how agents secure buyer loyalty and ensure clarity around commission agreements. A realtor, who does not explain and disclose this form and have it agreed to and understood by the buyer and signed by the buyer before showing any properties, is subject to a fine from AAR. The first offense is $500. The second offense is $5,000 to $15,000 and may not have access to MLS for 30 days. The Buyer-Broker Exclusive Employment Agreement, February 2025 version by the Arizona Association of Realtors, AR, is a legally binding contract between a prospective home buyer, and a licensed real estate broker, that establishes the terms under which the broker will represent the buyer in a property purchase. Here's a breakdown of its key components and their significance. 1. Exclusive representation. The buyer grants the broker exclusive and irrevocable rights to represent them in locating and purchasing a property during the term of the agreement. Signing multiple agreements could result in the buyer owing multiple brokers. 2. Term of agreement specifies the start and expiration dates. After expiration, the buyer may still owe compensation if they purchase a property the broker showed them during the agreement term. 3. Broker's duties. Locate properties matching the buyer's criteria, e.g., residential, land, commercial. Assist with negotiations and the transaction process. Work within the scope of their licensing. 4. Agency relationship. Defines how the broker represents the buyer, as set forth in an agency disclosure form or another defined method. 5. Property viewings. Buyer must work exclusively with this broker and be accompanied on first visits to properties, including model homes and open houses. If not, the seller or builder may refuse to pay the broker's commission, which could then become the buyer's responsibility. 6. Buyer advisory buyer agrees to review the Arizona Department of Real Estate's buyer advisory, which offers inspection and investigation guidance. 7. Broker compensation. Compensation is negotiable, not set by law or any board, can be a percentage of the purchase price, a flat fee, or another arrangement. A retainer fee, optional, may also be paid up front, refundable or not, depending on the terms. Compensation sources. The seller or listing broker may offer compensation which offsets what the buyer owes. If seller compensation is less than agreed, the buyer covers the difference. For VA loans, compensation must come from the seller, unless otherwise specified by VA rules. 8. Buyer's responsibilities must act in good faith when a property is located, can owe broker fees if they back out improperly, or close on a property negotiated by the broker, even after the agreement expires. 9. Listings and equal treatment broker will show all listings matching the buyer's criteria, regardless of seller offered compensation, unless the buyer says otherwise in writing. The broker complies with fair housing laws. 10. Conflict of interest and liability. The broker may represent other buyers interested in the same properties. Broker disclaims responsibility for legal, tax, or financial advice, but can recommend professionals. 11. Dispute resolution. Disputes go first to mediation, then binding arbitration, unless a party opts out within 30 days of mediation. Class actions are waived, disputes must be handled individually. 12. Legal provisions governed by Arizona law, allows electronic signatures and counterparts, includes a full integration clause. This is the entire agreement, no side deals allowed. 13. Signatures signed by both the buyers and the broker, and agent, if applicable, showing mutual consent. Why this agreement matters. This form creates a formal, exclusive working relationship between a buyer and a real estate broker. It ensures that both parties understand their rights, obligations, and how the broker will be compensated. For the broker, it protects their time and investment. For the buyer, it outlines services and sets expectations. In the event that the agent presents a listed property to the buyer, and the commission specified in the MLS by the listing broker is $10,000, with the agent receiving this amount at the time of closing, the buyer is not obligated to compensate the agent. Similarly, if the agent only receives $7,000 from the listing broker for the aforementioned scenario, the buyer would be required to pay the agent $3,000 at the closing. When the agent introduces the buyer to a property not listed in the MLS and the seller does not agree to cover the agent's fees, the buyer will be informed of this, and upon the property's sale, the buyer will owe the agent $10,000 at the closing. If the buyer opts to visit a new home subdivision or purchases a property at an open house through another agent without involving their own agent in drafting the offer, the buyer would owe the agent $10,000. Remember to always educate your buyers when they are looking for a new home purchase, that they must take you with them, and you must register them, or you may not receive a commission. You can sometimes register your clients online. You must also know that if they are looking for, say, a PULT home, each community will need you to register your buyer client, or you may not receive a commission at close. Buyer's broker should obtain co-broker agreement issue. The listing broker has entered into a net listing, which will not be placed on the MLS, with the seller. Under the terms of this net listing, the listing broker will receive all proceeds in excess of $120,000 upon the sale of the home. Can a buyer's broker be compensated under a net listing, not in MLS? If so, how? Answer. The buyer's broker can receive a portion of the commission earned by the listing broker under the terms of a net listing by entering into a co-broke commission agreement with the listing broker, preferably in writing, specifying the amount of compensation. Arizona Realtor, RR, Digest August 2000, reviewed May 2004. Remember that your duties as a client's agent are terminated at the successful close of escrow. Here is an example. Facts. The brokerage represented the buyer of a property in 1996. As part of that transaction, the buyer obtained title insurance, and the title company disclosed to the buyer that there was an easement for access to the property. Recently, however, the buyer was informed that the easement is allegedly invalid. The buyer and a neighboring property owner are litigating the dispute. The buyer has also sent several demand letters to the brokerage, in which the buyer claims that the brokerage has an ongoing obligation to assist her in resolving the dispute and potentially participating in the resolution. How can a buyer's agent be assured that they will receive a commission at the close of escrow? In the contract, on line 37, the box for seller compensation must be checked, and the seller compensation addendum is attached to the contract offer. Of course, this is a negotiable item and may be countered or accepted as offered by the buyer to the seller. The Buyer-Broker Exclusive Employment Agreement. The first thing you should know is that the first line on the BBEEA states, "Notice to buyer, all realtors are required to have a signed written agreement prior to showing a home to a buyer." The first offense for a realtor are showing a home without properly disclosing and having the BBEEA signed by the buyer is a $500 fine by AAR. The next fine is $5,000 up to $15,000 and could lose 30 days of access to the MLS. While resistance to the utilization of the BBEEA form persists among many brokers and agents, there exists a practical rationale for agents to embrace it. It is required. Essentially, it functions as a bilateral agreement, similar to a listing, granting an agent the authority to claim compensation from a buyer even if the property is purchased through another agent, at an open house, or directly from a builder. In comparison, an exclusive listing agreement with a seller ensures that the agent is compensated upon the sale, regardless of the circumstances. The parallelism between a listing agreement and the BBEEA form ensures the agent's entitlement to a commission, irrespective of how the property was purchased. If, as a seller's agent, you secure an exclusive listing agreement for 6 months, with the seller committing to a $10,000 commission, the expectation is clear. You anticipate payment upon the sale. However, if the seller sells the property privately without your knowledge, pursuing the commission might involve legal action. A bilateral agreement, such as a listing agreement, guarantees the right to collect a commission, regardless of the buyer or the method of sale. The same principle applies to buyers. By endorsing a BBEEA, the buyer commits to compensating the agent regardless of the property's source during the agreement's term. Whether the buyer explores an open house, engages with a new home builder, or collaborates with another agent, the agent retains the right to pursue a commission. This places the decision to settle or pursue legal action entirely in the hands of the agent, not the client. Remember that if you put in too much detail and the buyer finds something outside of those parameters, the court may not go your way. The buyer may say that you did not show them what they were looking for in a location on the form. Consider this scenario. After investing significant time with a buyer, she informs you that she purchased a house from a builder. While she rejoices, you've essentially watched potential earnings vanish. If the buyer had signed the BBEEA form, the agent would have the option to demand a commission and pursue legal action if desired. The power lies with the agent, allowing them to choose whether to settle or pursue the client for compensation. It's crucial to note that exclusive buyer representation and the use of the BBEEA form require approval from the broker. While a broker may permit the form's use, they might not authorize the collection of a retainer fee. Agents should ensure full broker approval before implementing the form and should be well versed in the form's contractual obligations. When the era of short sales was upon us, the use of a retainer was used many times. Agents would do a lot of footwork only to have the buyer change their minds, as they could not be accepted as the winning bid on many homes they tried for. Sometimes, if you are listing $1 million property, and you would be putting out money for advertising in luxury magazines, having amazing photographs taken, and video tours along with the drone shots from above, you may want a retainer. This retainer could be non-refundable if the property does not sell, or if it does close successfully, then the retainer could go back to the seller at that time. Despite the belief that the BBEA form places agents at a competitive disadvantage, those who have embraced it argue otherwise. Agents and brokers attuned to the form claim stronger relationships with serious, qualified buyers, resulting in increased income. Making the form mandatory can deter non-serious buyers, potentially saving agents from commission reductions. Additionally, the form addresses the issue of commission reductions that agents often face, leading to an overall increase in income for those who regularly close transactions. A note for you. When you offer a credit of your commission back to the client, remember to always think about all the scenarios that could happen. Example: you start working with a buyer. You have sent them searches of prospective properties within their parameters. They have selected 10 to view over the course of a week. At the end of the week, they have finally found the one they love. Purchase price $178,000. The commission offered by the seller's agent is 1%. Let's do the math. You promised you would give back 1% of the purchase price to the buyer at a successful close of escrow. How much of the $1,780 are you going to realize? Nothing, and you will owe your broker any fees associated with that transaction, so it might behoove you to figure out a credit scale. If you receive 1% commission, the buyer will be credited maybe 0.5% of the purchase price. If you are offered a 2% co-broke, the buyer receives 0.75% credit, and so on. You can't just offer all of your commission. This is what puts food on your table and a roof over your head, along with other costs, insurance, car, fuel, and maintenance, healthcare, classes, and realtor fees and dues. Don't work for free, or just do a flat fee. You need to show your value as an agent and what you offer your client as services. Getting to know their needs and timeframes, searching for homes. Write up offers and know how to negotiate the price. Order and navigate through the inspections and the inspection period. Coordinate with the title, escrow company, lender, and repairs. Make sure all is done prior to the deadlines. Keep all paperwork in order. Educated the client about the transaction process. Be on call to advise, answer questions, and make sure all forms are completed correctly and done on time.